Maybe. I'm not sure what is.
You or me? What do I want? Oops. Just a second. Trying to adjust my camera. There we go. That's good. Hey guys, we're just going to be starting up in about 5 minutes, and I just wanted to test a couple of things to make sure that all the things are working properly. If you can hear me, can you please put in the chat bar that you can hear me? That would be fantastic. And Paulina, if you can also talk, that would be great. So we can test out the sound, please.
Can hear you well.
Awesome. Great job. So, and we're just testing out the chat bar as well, everybody. If you can just put in the chat bar where you're coming from, that would be awesome. For those that are watching me live on Facebook, hello. This is our first time doing something like this. I'm actually on a webinar that you can watch on my YouTube channel. So if you haven't subscribed to me on YouTube, go and type my name on YouTube. Something should pop up. We're actually doing a live webinar right now with Paulina, and we're going to talk about a very important topic, and it's all about the wills. If you're currently alive and kicking and you're over 18, you should be thinking about your future. You should be thinking about the wills. So if you have nothing to do right now, if you're chilling on the couch, if there's nothing on telly, come and jump in. We're going to make it very interactive. It's not going to be a boring one. We're going to give you the real information. Thank you, Duncan. Appreciate it. You can hear us. That's awesome. Cool. Yep, so jump in and have a listen to our webinar. It's going to go in for the next half an hour to 45 minutes, and you've got a chance to ask questions from Paulina in real life. So just to let you know what's happening here, I'm just going to turn this around. There we go. We're just on the webinar right now. All right, so I'll be looking mostly this way. I hope. Okay. Duncan, where are you from? Where in New Zealand are you from? Can you please put in the chat bar to let us know? Jim, hello, our regular. Thank you so much for jumping in. Where are you from, guys? I see Dennis. We're just going to wait a little bit longer for more people to jump in. I'm going to hit the record button as well, just so we've got it. Okay, correct. Awesome. We've got a Capita Coast. And Paulina, I'll just get you to share your presentation for a moment just to make sure that it is working, please.
Yes, just give me a second.
Now, can you talk, Paulina, please? Because I want to see if these guys can actually hear you. I don't know if they can hear you.
Yes, yep. Just give me a second. I will share the presentation. Gosh, every time we do it, and then I forget. Where do we go? Where do I go?
We've done it so many times. You should be
Oh
an
my
expert
God.
by now.
Yes.
Take this off,
Oh,
guys.
it's in the Zoom. It's in the Zoom. That's right.
Go.
I was doing that in the PowerPoint itself. It's in the Zoom, isn't it?
It's in the
Share.
Zoom.
Yeah, share. Microsoft PowerPoint on my desktop. And it's that. And it should be play from start or something like that. Continue to share.
Yep.
Is that?
Yep, I can see your presentation. Yeah. Fantastic. Thank you so much. Awesome. People are coming in. Welcome, 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 everybody. So good to see some familiar faces and names. Some new names as well, but some old friends here. Welcome. Thank you. Just to let you know, we're going to start in about a few more minutes. I'm just going to give a few more minutes. But meanwhile, for those that have just joined in, can you please make sure the chat bar is working for you? Drop us a message. Where are you logging in from today? Because what we want to do is we want to make it interactive for you. And we're going to allow space and time for you to ask those questions that are probably bugging you. And after Paulina's presentation, I'm going to ask those questions from Paulina and get her expert advice. So please make sure the chat bar is working. So please message us in the chat bar at the bottom where you're logging in from tonight. Thank you. Hi, Natalia from Auckland. Yay, good to see you. Thank you so much for coming in. Good to know that my newsletter worked. Cool. Wellington, Oni, hello. A long time no speak. Good to see you, my friend. Evan, hello. Paulina, Evan was at our webinar last time as well. He was asking some good questions. Welcome back.
Right.
Always good to see people that have come to our previous webinars. For those who have missed the previous webinar, all of my recordings are on YouTube, so please go and have a look at them. So good to see you guys. Thank you. Just going to give a few more minutes, and then we're going to start. And I'm just checking in. So it's funny, you guys see one angle, and then this guys will see completely different angle. Don't know if I should turn it. Okay. All right. So, Paulina, should we kick off?
Yes, happy to start.
All right. Let's give it a go. Awesome. Well, welcome everybody. Thank you so much for jumping in. If you're here, you probably know me, but just to let you know, I'm Zibunisa Alimova. Today I decided to say my full name. I'm Zibunisa from Kapiti Coast. It's a little bit chilly out there. That's why I had my scarf. So if you see me put my scarf back on, I apologize because I do have a bit of a funny throat. It's an interesting one tonight because we often don't like to talk about things that happen if we die, but it is an inevitable topic, right? We all eventually die, and we need to know what happens after for our loved ones, for our family, with our staff. So this is a very important webinar to be part of, and I'm so grateful that I'm joined tonight by Paulina. Paulina, hello.
Hi, everybody.
Paulina, I am absolutely grateful to you for sharing your time, out of your kindness. I know how expensive lawyers are these days. So to have someone like you to jump in and share your knowledge for free with us, I'm beyond grateful to you. So thank you. And I hope our listeners tonight will get something out of it. Guys, if you do have any questions, please feel free to use the chat bar. We will ask those questions at the end. We'll let Paulina to start her presentation for us, and we'll ask her as we go. So Paulina, take it away, my friend.
That's great. Thank you for having me. I'm grateful to present. And I mean, it's one of my favorite topics. I love to see people arranging, their wills, getting their affairs in order, because nothing hurts lawyers more than when simple things that could have been dealt with, by a will, have to be dealt with in a very difficult way. Basically, something that could have, taken 4 weeks becomes 3 or 4 months matter. So it would be great if some of you take anything from that. That would be great from this presentation. So as Vanessa already introduced, we're going to talk about the basics of succession and why it's important to have a will in New Zealand, even if you don't particularly have a lot of assets. And for everybody, that would be different. But I'll, what it means to have a lot of assets, but I'll talk about that. Just a little bit about me. I've been practicing law for 9 years, and I specialized from the very beginning in the private client area of law. That was always my passion since university, so I went straight into that and love the area, basically. Around 50% of my work is in relationship property, and the rest is in estate planning, asset planning, and estate planning structuring. So that includes trusts, wills, and so on. And I also do elder law, which is quite a specialized area as well, that concerns advising elderly people, assessing their mental capacity when it comes to entering into wills and enduring powers of attorney and so on, and at a later stage of life. I am a full member of the Society of Trust and Estate Practitioners. That's a worldwide organization. It's basically a professional body that governs trust and estate practitioners worldwide. And I regularly publish articles in New Zealand and overseas. Love doing that. Last year, so almost a year ago, I went out on my own, established my own advisory. Again, I only specialize in this area of law. So at PK Law, which is the name of the firm, we advise on succession planning, wealth structuring, estate administration, elder law, and relationship property. We don't do anything else other than that. So we just stick to our specialized areas of law. Got a slide on Zibunisa there, but you already introduced yourself very well. Yep.
Thank
So no further introduction required, but Zibunisa is great and she gives to community so much. So very grateful for you for running this webinars. And before we get into the interesting part, just a disclaimer that obviously this is not legal advice. This is just general information because everyone's situation is different. And if you do need legal advice, please reach out. All right. So we'll start with the basics of succession law. So a little introduction into how the law, succession law in New Zealand works. So unlike civil law countries, in New Zealand, subject only to few exceptions, you can leave your assets to whoever you want. The exceptions to that being the Relationship Property Law, the Testamentary Promises Act, the Family Protection Act, and the Family Protection Act. So relationship property law claim. So that the relationship property law is the law that states that 50% of relationship property of the couple has to go to one of the partners, right? So the 100% gets split equally. And should you not leave to your partner 50% of their relationship property that they're entitled to, they are entitled to make a claim against your estate. The Family Protection Act is when in your will you have not made an adequate provision for someone who the law specifies you was relying on you to properly maintain them and support them. And the people who are entitled to make that claim are the partners, so your spouses and partners, the children, the grandchildren, stepchildren, parents who were maintained by you, and parents who were not maintained by you, but if there's no one else left to claim under your estate because everybody died. And interestingly, siblings cannot make a claim. So your sisters, brothers don't actually have standing under the Family Protection Act. That surprises a lot of people. So, and the Testamentary Promises Act, that's the act which says if you promised to give someone something in your will, in return for them helping you out, for example, providing services or looking after you when you were elderly, yeah, they can make a claim as well if you left them out of the will and didn't fulfill that promise. Relationship Property Act that sets out the procedure for division of assets and separations and procedure for contracting out agreements. And a note there in terms of what I've mentioned in terms of the assets. So even if you don't have a lot of assets, you do need a will. So that's in the context of the fact that currently, and that is finally changing in September, if your assets are lower than 15,000 at each individual institution, for example, your bank account is under 15,000, your KiwiSaver is under 15,000, you can get those assets without requiring probate. So basically, you wouldn't need your will to be sent off to the High Court to be probated before you can access those assets. So it makes it easier for your family members to receive those assets without having to wait months and spending a lot of money on lawyers. But in saying that, banks and KiwiSaver would normally still want to see a will to see who you left it to, because if you don't have the will, then it will be the Administration Act that would apply. So that threshold of 15,000 is increasing to 40,000 in September. So in less than a month now. That's
this is huge news, right, Polina?
It is, yeah. It's been long overdue. So
Yeah.
it's basically because KiwiSaver came out in 2009. And since then, no one, basically, most people have KiwiSaver these days. And one of the main assets when people die is the KiwiSaver. So the government didn't really intend for people to have to apply for probate just for that KiwiSaver. And the government recognizes how expensive it is to get probate. And there's just no need for it. So yeah, it is big news, and it is going to make life easier for so many people. I've seen and I've been involved in cases where we only had to get like 40,000, for say a spouse of the deceased, and there were maybe 20 in one bank, 20 in another, so it was over 15,000 just by a little bit, but you had to go and get probate. And if the person died without probate, it's letters of administration. So you're looking at a cost of, in that case, it was around 10,000. So, from the 40,000, you only, the deceased, the spouse of the deceased got 30. So it is huge news, and yeah, it's going to make a huge difference for a lot of people. Mm. Right. So wills generally. So wills are governed by the Wills Act 2007. The Act sets out how the wills need to be signed, what affects their validity, and how to validate wills that haven't been properly executed. Under the Act, even a handwritten note or voice recording can be validated as a will, but it is a very expensive process. So it's not something that you should be aiming to do. You should be aiming to have a proper will to make it as smooth as possible for your family to deal with it when something happens to you. Wills can become very complicated when they concern situations like this, so children from previous relationships, overseas assets, or non-New Zealander having assets in New Zealand, relationship property issues, and trusts. That's because the cost of the will is not the drafting of the will itself, and most times it is the advice around the wills in terms of what claims can be made and why you shouldn't do this, and if you have trust, what powers should be dealt. If you have overseas assets, it's a whole other level of complexity in terms of planning, and often you have to work with a lawyer from another country to make sure the wills don't contradict each other and that they are going to work well, as opposed to make things even worse. In your will, you can appoint a guardian for your minor children. That's important for a lot of people who might not realize, especially for separated couples, where each parent want to appoint someone else other than the other parent to be a testamentary guardian. So, if say the couple is divorced and the wife dies, she won't say maybe her sister to have input into her minor children's life, not just the father. So that can be dealt with in the will. I've mentioned cross-border estates. So yes, when there are overseas assets, that becomes very complicated. And it's all doable, but yeah, it just requires specialized advice to get things right.
Okay, so I'll just stop you there for a moment,
Mhm.
or you may already have an answer. We've got some questions coming in, which I think are related to what you're talking. So, for instance,
Yeah,
if
great.
someone already has a will, but they have no idea what lawyer did it because they would have done it, 5 years ago, 10 years ago, can they use another lawyer to deal with that will, or do they have to start from scratch, or like how does it work?
You mean to get a new will?
Yeah. So
Yeah,
if
yeah,
they get a
yeah.
new will, will
It
that
revoke the previous
cancel?
will. Yes, yes,
Yeah.
yeah.
Okay.
Yeah. So you can do your will anywhere and it will automatically revoke your previous will. And what happens on death, for example, what happens on death, if your family members, if you have a copy of the will at home or they know about it, your latest will, they will just have a copy of it. The other law firm that's holding the will that was done prior to your latest will, each law firm checks death notices, so they would probably see when a person died and that it was their client and they hold a will, so they might reach out to the family and the family would actually say, well, there is a later will and that stands. Yeah, so don't need to go to the same lawyer.
Okay. Okay.
Yeah.
So to answer Jim's other question, does it cost to do that? Yes, it will cost you from the new lawyer to
Hmm.
create a new will.
Yeah. And the thing is, if you go to a new lawyer, whether you have a copy of your old will, even if you provide a copy of your old will or not, it's really is the same thing because it's about the advice. If that lawyer hasn't previously given you advice, they have to give you that advice. But even if you go to your current lawyer, and it's been a few years, your situation has changed. So your current lawyer would also be giving you a new advice because, yeah, years passed, your assets changed, your situation changed. So, and the law has changed 6 years ago. So if your will was done prior to that, there's way more obligations on lawyers since when they provide advice on the will. So even your current lawyer would have to go through that process. On that note, in terms of revocation, good place to mention that is that marriage revokes a will. So if any of you got married since you had your will done, that automatically revokes your will. And basically, you end up in intestacy position, whereas you didn't have a will. So you do need to make a new will, unless your will did say that it was done in anticipation of the marriage. to a particular person. In that case, that would be okay. And normally your lawyer, you would have needed to tell your lawyer who you were planning to marry for them to incorporate that in your will.
Okay.
All
Thank
right. So in terms of getting the will done, so the process is a will maker has to sign the will and initial it on every page in front of two adult witnesses. And those witnesses cannot be beneficiaries under the will, and they can't be the executors as well, ideally. They also then, so the witnesses need to sign the will and initial it on each page as well. So in that sense, that the signing of the will is a very unusual process and very specific, and doesn't matter sometimes how many times you tell the clients, if they sign it by themselves, they will still miss an initial, and it's not a huge problem, but it would increase the cost when you apply to the court for probate, because the court is going to question why there's no initial, and you have to do all this additional steps that you wouldn't need to do if everything was signed properly. A will has to have an executor, a beneficiary, and it must deal not only with specific items of the deceased, but also with the residual estate, as otherwise a will can lead to intestacy, which is the whole point of making a will, is not to end up in that situation. So what that means is, if you have specific gifts like 10,000 to that person, or my car to that person, my jewelry to this person, you then need to have a clause which says, and the rest of my estate as follows, because there will always be something else. And if you don't have that clause, then basically then it's not clear, well, who's going to get the rest. And that can lead to, could lead to intestacy, which means you basically have no will and have to go through the complicated process. And the above is why an online will costs 2 or 3 times less than a will attended to by a lawyer. It is because it's very easy to for essential elements to be missed in an online will, which can lead to unintended consequences. One of the things is checking titles to the property ownership, because there is a difference between joint ownership and tenants in common. So joint ownership means the property is owned jointly by you and someone else. And it means you cannot deal with it in a will, because if you do, nothing's just going to happen. It's going to still pass to the surviving joint owner. Doesn't matter who you leave it to in your will, it will go to the surviving owner. For example, if you own a property with your friend and you're leaving it to your child, it will go to your friend if you own it jointly with your friend. Or a more common scenario, you own it with your spouse and you want to leave it to your child from a previous marriage, for example, but your spouse would get it if it's registered jointly. If it's tenants in common, meaning it's half shares, so 1/2 share each, or maybe you own it in unequal shares. When it's tenants in common, you can leave it, obviously, in your will to whoever you want, subject to this other exceptions in terms of relationship property. So that's why it's important to check the will. And if a lawyer is acting for you on a will and they don't check the title, and for example, you were thinking you're leaving half of your share and your family home to a child from a previous relationship, and then you die and it goes to your current wife, who's not the mother of the child, your child can sue the law firm who gave you that advice and so on. It's not the same for online wills, because no one carries responsibility there, no one checks the title. So it's just, you just get it done and hope that maybe it will work, but it might not. So
That's
yeah, online.
That's like everything in life right now, isn't it? You do something online and then you hope it works. I mean, same applies to our mortgage industry when people go in and click buttons and they go, "Oh, the calculator on the bank's website said I can borrow 1 million." You're like, not really.
Yeah.
Okay, that's really interesting points there, Polina. What I want to ask you, that our listeners are asking
Mhm.
here, which I think suits your current page of the presentation, is
Mhm.
can a couple have one shared will?
No, no, they can't. No, everyone needs an individual will, yeah, their own will.
Oh,
It's a good question. Good question.
all right.
Yeah.
Yeah. And then how does the joint ownership work for finance owing?
I guess that means in terms of the debt,
Yeah.
if you die, can only suspect that's the question, that if you die and say there was an outstanding mortgage, well, how it works is that both owners are responsible for that loan. And if it's joint ownership, it will basically go to the surviving owner. So then they will be left with that debt. They would have to sort it out. And I recently had a case, exactly that, but family where husband and wife, and the wife did want it to go to the husband, and it was joint ownership, but they are quite elderly. Well, he's quite elderly. She died, and it was jointly owned, and he had to refinance in his name, and there were difficulties with the bank. Or Dzivanisa, of the client, it's a
Yeah,
mutual client of ours.
we worked on that case together.
Yeah. So had to jump through a few hoops, but basically, yeah, you need to refinance and deal with it. And if you can't refinance because you on a pension and you can't, then I don't know, you might have to sell. The bank just wouldn't give it to you, wouldn't refinance it in your name. So people find themselves in those situations as well. Yeah.
So
That's why there's life insurance and all those things exist as well, to make sure that if you die, your surviving spouse can actually pay off the mortgage to stay in the property.
But this one was an interesting case because she was elderly as well, right? So, but they had mortgage. So this is where it gets tricky, because if you're older, the life insurance also gets expensive. But that's a completely different webinar, which will happen next month. So please come to my webinar next month, where we're going to talk about life insurances and how that's going to help you. But in this particular case, what we need to really stress is that doing it online is completely different to getting proper advice from a lawyer that will set it up for you in the way that you need to. And actually, funny enough, we have questions coming from 3 different platforms. I'm very proud of my my team tonight. You guys are awesome here, all the listeners. So we've got a question here that how much does an in-depth customized will cost? Not one done on the internet or website. So in relation to how much it costs online to a normal legal advice, Paulina, in your opinion, how much does it cost?
I should actually check this out. I don't know how much it is online. I can only suspect maybe $200 or $300, something like that. And obviously, every lawyer is different, but I was going to talk about the prices. For example, at our firm, it's the starting price is if it's a new client, 650 plus GST for one will, and that's quite a simple will. And if it's a couple, it becomes a bit cheaper because usually the wills are quite similar. So there's a discount for when a couple, and it goes up. But yeah, as the complexity, because as I said, sometimes you can spend months if the kids from previous relationship, and you do a lot of planning. So it's not just the will, but the planning of how to best structure. If it's a simple will, there's 2 kids, that's our price, but every firm is different. You can go to some general firms who just have a template, and they do it cheaper, or sometimes when you're also buying a property, you get a discount. But yeah, general, I would say 500 to 700 is kind of the industry standard for a simple will.
So, Gulnush, to answer your question, can a couple have one shared will? You can't, but there is a discount.
They can get this.
To come together.
I was going to say the will is probably one of the most important documents person can make in life. Like when you think about it, it's a pretty important document. So, it is worth spending a few extra $100 on it, but getting it right for the sake of your family. A lot of people think, oh, when I'm gone, like just leave it to them. But and be nice to your family. If they're nice to you, be nice to them. Get it sorted. And it's not just that you worked hard for your money. Do you want 10 grand to go to lawyers just for sorting out something like intestacy, applying for intestacy, when you could have spent 2 or 3,000? Like you work hard for your money, so why would you waste your money on these processes that could be avoided? So that's how I think about it. Okay, so what happens if I die leaving a will? So I'll just take you through the process of what happens in practical terms, because actually clients often ask that, well, I'm not there anymore. What happens? What does my family need to do? So executors, so those people who you appoint to carry out your wishes, they will normally find the will maybe at your home, or if it was in a law firm, the lawyers would contact them. and then we hold a will, or we hold a copy of the will. We can assist you. They will see the lawyer. The lawyer will help them, will draft the probate documents, which are usually quite straightforward, especially if the will was signed properly. If there are executors in the will and there are beneficiaries, it was signed properly. So it's all easily done. It gets sent off to the court, and it takes around 4 to 6 weeks to get a probate. Probate is a document which says, yeah, these people can administer the estate. They can now go to banks and KiwiSaver and give the document and start collecting the assets. One of the reasons why you don't want to appoint, for example, an overseas executor, and I deal with that commonly with clients who don't have a lot of family here, right? Maybe husband, wife, and a child, parents overseas, friends overseas. You can appoint an executor overseas, but it's not advisable only because they do need to sign original documents, which these days you don't really get to sign a lot of original documents because there's no need for it. But with probate, that's one of the things. The document need to be original, so it would have to be sent off to wherever country your executor is. They have to find a notary. If it's not UK, Australia, there are notaries, so the process is just a bit more complicated and longer.
Okay. Alina, just a second. So before you move to the next one, basically, this is the best ideal scenario for you, is for people to have a will, right? If something happens, people have a will. It's so much better to do all the steps.
I mean, as a lawyer, I like dealing with situations where there's no will as well, only because, of course, it's interesting. Of course, it is. Sometimes you get situations that are unique, and the law is complicated. So it's interesting to deal with them. But do I feel for the clients like, oh my God, why are you in this situation? I do, and I do wish they just had a will for their benefit. Yeah, so definitely the ideal situation is a will properly executed, that you send off to the court, and the court just, yep, no problem with it. Yeah.
Okay, thank you.
And in contrast, what happens if I die leaving no will? So if you die without a will, the distribution of your estate is governed by the Administration Act. So that's an act where, the act that sets out who is going to get what. It can have unintended consequences because a lot of people don't realize what it actually provides for. So currently, the first in line is the spouse and partner, and they receive the first 155,000 of your estate, and that figure can change. It's been at that amount for a while now, but I suspect it will change at some point soon. And then the spouse partner receives 1/3 of your remaining estate, and then the children receive the 2/3 of your estate. If there is no spouse, then it goes to children. If no children, deceased parents, and then siblings, and then grandparents, and then uncles, aunts, and finally the government. So if you don't have any family, anyone, it goes to the government. Or if there is family somewhere overseas and they didn't know, or no one could find them after a certain period, it goes to the government. Many people get surprised that the spouse partner may receive less than half. So that's if the estate is large, right? Because if you calculate if the estate is, say, 5 million, the spouse would receive the first 155, then 1/3, whatever that would be. But if you calculate, the children would actually receive the largest share between them. A lot of people find it surprising because they always thought, people think that the spouse would receive more and the children less. And because there are people who don't want the children to inherit, for example, or some might not have relationship with their kids at all, and then they have no will. So, unintended consequence for them. And yeah, many people get surprised that children might not receive a lot if the estate is small, so vice versa. So if, for example, your estate is only, say, 200,000, and say you have kids from previous relationship. I say previous because if you have joint children, normally you expect your spouse would provide for them after he or she dies as well. The children would inherit at the end. But when it's children from previous relationship, that's when it becomes complicated. Because, yeah, if your estate is, say, 200,000, your partner would receive 155,000, and then the 1/3. So 45,000 left, split it 3 ways, basically, to the spouse, and the 2/3 of 45,000 to the kids. So your spouse would receive the most.
Wow, they just blew my mind. Let me just repeat this quickly to our listeners over this way. So, guys, if you've missed this, basically, the if you don't have a will and you've got a partner, and the partner, if you don't have a will, you've got a partner that you die, the partner will receive 155,000 and a third of the remaining estate, and the children get the rest. And as Paulina rightly mentioned, so if the estate is huge, let's say 2 million, right? You died, you left $2 million dollars behind in your KiwiSavers bank account, etc. Your partner will only get 155,000 plus one third of your estate. However, if you have a small estate, so let's say you only have $155,000 in your bank account, your partner will get it all. There'll be nothing left for your children. And especially if you have like 5 kids, for instance, or 4 kids like me, the kids will not be happy with that outcome. Yeah, this is crazy. So, yep, Steve, you definitely need to get onto that will. Absolutely. Sorry, Paulina, carry on.
Um, so dying without a will, process and cost. So as you can see, the difference between the process, so this slide, what happens if I die leaving a will, right? Pretty much one step. You fill in the document, send it off to the court. And then this slide for what happens if you die without a will. So you can already see where it's going in terms of time and how much, money would be spent on this. So if you die without a will, your family needs to decide who will apply to administer your estate. And family members need to provide written consent that they're happy for the person who applies to be appointed. So if your family members are all over the world, you can just imagine they need to complete all these documents, their consents. And then in some families, it might be hard for them to agree who's going to apply. I mean, there's an order in terms of if you have a spouse, the spouse might be first in queue, and then there's children. But if there's no spouse and say there's 5 kids, and then all these 5 kids are fighting over who should be the executor, that could lead to a lot of problems. You would need to there would need to be a publication advertising. It's called a will search. So basically, it will be an advertisement. Usually lawyers. So you go to lawyers, and lawyers publish it in Law Society, which basically says we're asking all lawyers to check their records and see if you hold a will for the person. And then when the executors, the administrators, people who want to apply for the letters of administration, they would need to swear that they've actually done a search in the deceased home, that they are quite certain that they didn't find a will. If a male person dies, there would need to be a document, so paternity search. So that is to make sure that there's no unknown children, left behind who are entitled to inherit. So that, of course, costs extra. And again, time delay. It can take around 3-4 weeks to get the paternity search. Unlike with a will, if the deceased died leaving a spouse or partner surviving them, that partner must obtain independent advice and make a choice to receive under the Administration Act or under the Relationship Property Law. There is no similar requirement for a will, but there is this requirement for letters of administration, which means that surviving spouse needs to go to another lawyer who's not the lawyer acting for the state and get that independent advice. And as part of that independent advice, that independent lawyer will sign a document called the Notice of Choice of Option that then needs to be annexed to the application when it goes to the court. So again, time delay, and you're looking at significant amount of money to get that independent advice. Documents that need to be prepared are way more complex than probate documents. So just preparing them for lawyers is way more work. And yeah, due to this extra requirements, the cost is at least 2 or 3 times more than applying for probate. And it takes longer than probate. And yeah, if you have family residing out of New Zealand, this can become very difficult. Yeah. Do you have any questions on that one?
There are so many questions flying. I think by far, Paulina, this has been our most successful webinar.
Oh, that's good.
Everyone cares about the will. That's
That's
awesome.
great.
Where's the will, there's the way. There's so many questions. I don't know whether you want me to ask them now, bit by bit, or whether you're gonna cover it. I don't know.
I'm
What
happy for you
lies?
to ask as we go. I think it's maybe more interactive, and yeah, happy
Okay.
to do that.
So we'll just address quickly Steve. So he's asking, is it advisable to have a copy of your will at home, and where is generally the best place to keep them?
It's a good question. Um, so it differs. Some law firms hold a copy at the original will. That's how it's been done for many years. And one of the reasons for that is that it makes your family, they have to go to that lawyer because they hold the will. And normally you would apply through that lawyer for probate, right? Or at least that's what the law firm hopes. We hold the will, you're going to use us for our service. So that's one of the reasons why a lot of law firms hold the will for free, because they hope that that will come back as more work in the future. But you don't have to, the law firm doesn't have to hold it. A lot of firms these days don't hold original documents. So you would just have the original at home. And yes, you would keep it in a safe place where all your documents are, or say maybe where you keep photos or something where, your family would go through. Um, and yeah, and the lawyer would keep an electronic copy, because although you do need original will to apply for probate, if that original will is displaced, lost, you can still apply for probate. It's just one step more complicated, but it's yeah, it's doable and happens quite often. Yeah.
You just reminded me, I think you and I did my will last year, and I have no idea where I put it.
You don't hold the original in your
I don't?
case.
Okay,
No,
good to
no,
know.
yeah.
Okay, good to
Yeah.
know. Phew. All
Yeah.
right. Steve has another question. Is a partner defined as living together for 2 years or more? We've covered that in our last webinar, Steve, so please have a look. But we're going to answer that question for you anyway.
Yeah, of course. Yeah, it's a good question. So, de facto partner, when I say partner, it's a de facto partner. And yes, that's generally when you've been living together for over 3 years. I want to say generally because it's possible to be in a de facto relationship when you have lived for less than 3 years, but very unlikely. Unlikely, yeah, but possible. And similarly, um, you can. I'll give an example that I gave in the previous webinar is, you might have for example, elderly people, they might live between houses, have a companionship, so they might um, not live together in the same home for over 3 years, but they still might potentially be in a de facto relationship if they have that and a lot of commitment to each other and their connection. So yeah, trying to make it simple, but sounds more complicated because there's a lot of but yes. So de facto partner is generally when you have lived for more than 3 years together.
I think that was a perfect lawyer response.
It depends. It depends.
Depends.
Yeah.
Okay, a couple of questions from our listeners on this side. So I'm just going to read them out for you to make it easier, which was actually one of them is really, really interesting. Can someone go behind their partner's back to redo the will, to leave it to everything to their children? And can it be contested?
Yes, you can change your will at any time, and it doesn't depend on the other partner. The only exception to that is if you do what's called mutual wills. So mutual wills, it's are wills that have an element of contract. So there would be a clause in it which says that both parties agree that neither can revoke the will without the agreement of the other while they are living. And yeah, so that's the only exception to that. So if you are worried about that, and it normally is when there are children from previous relationship, and for example, people often structure it in a way where partner A leaves everything to partner B, but he or she wants to ensure that when both of them die, it goes equally, say, between their kids. So when partner A dies, the partner B can't change the will and remove partners A children from that will. So that's one of the reasons you would enter into mutual wills. So there is a way to do it to ensure it can't be changed. And in terms of contesting, can you contest it? Trying to think, it wouldn't be you contesting, it would be, for example, or actually, sorry. So if your partner has died and he took you out of the will and left it to his children, yes, you can contest it. on the basis of there are a few. Well, one is relationship property law. So if it was relationship property in question that your partner left to someone else and you're entitled to 50% of that, you can make a relationship property claim. And then there is also the Family Protection Act claim. So relationship property entitles you to 50%, and Family Protection Act might give you even larger share if your partner had a responsibility to maintain you. So there might be a little another award in that sense. So yeah, there are definitely ways to contest it.
Interesting. Okay. And this one also, I thought that was really interesting because now we live in the informational, technologically advanced times, right? And our wealth is built from various many things. And the question here is, what about the crypto thingy? Should the person give the details and passwords, etc., written in the will?
That's a good question, and it is one of my areas of interest that I try to study a lot. And there are a few articles on my website on that point about digital assets. And I deal with wills that concern digital assets quite often. So you don't want to put anything, no keys, no passwords in your will, because the will becomes a public document. Once it goes to the court and is probated, anyone can request a copy of that will from the court. So definitely no sensitive information there. You keep that. If you keep the will at home, you can keep another document with the password somewhere together with the will, but it should not be part of the will.
Okay. Okay. Interesting. This one again blew my mind. So I'm a joint owner on a life insurance policy. With the Administration Act, would I then
Mm.
owe the estate given I'm only entitled to 155K?
No, no, because insurance, if it's a joint policy, the joint owner, same as the joint owner of a property of real estate, just inherits it, and it's inheritance outside of estate. That's the beauty of joint ownership. It's completely outside of your estate, of your will. So that's one way to protect your assets from claims by parties, is to own them jointly. Similarly, why people have trusts. If they don't want, say, kids from previous will or something to claim, you put asset in the trust, and that takes it outside of Family Protection Act claim. So yeah, no, you're not gonna owe the estate money. You would just get it.
Okay, that's really good to know.
Mhm.
And I guess that's just answered the next question that we had, that you mentioned that joint ownership of a house will go to the surviving one. Will that be included in the estate in the case of no will? If there is no
Yeah,
will.
no, yeah,
Okay.
no, no.
Now, what about the kids under 15? If you don't have a will, what will happen to them?
If you don't have a will, what will happen to the kids? Um, so if kids have two parents and one dies, the other parent automatic, well, the both parents are testamentary guardians. So it's the surviving parent who has the say in the child's life. And there are two different concepts in New Zealand law. One is the testamentary guardian. So that's a person who had the say in important decisions of the child's life, like which school to go to, if the child wants to be religious, decisions about that. And then there is day-to-day care. That's where kids stay. Do they stay 1 week with mom, 1 week with dad, or always with mom, or always with dad? So basically, yeah, that goes to the surviving parent. Um, yeah, and if you didn't want that to happen, that's why you need to set up a will and set out your wishes in that regard.
Okay, that's good. And that brings me to Steve's question of, can a child contest a will of a parent if the child has been left out of the will? So I assume that would be like an adult child that can contest, because I don't believe little kids can contest. I don't know. Tell me, Polina.
No, yeah, kids minors can contest, but they would
Oh,
just do that through not testament, litigation guardian. So
yeah.
someone would be appointed on their behalf to represent them in court. Um, And yeah, so they can. And can kids contest if they're left out of the will? That was the question, right? Yes, they
Yeah.
can. And it's the Family Protection Act claim, that there is a moral duty to support the child. And the outcome, it depends. It's on case by case basis. Adult children generally um, cannot expect to receive a lot if they are self-sufficient. They don't have problems like, financial, they're not struggling, they're working, they're self-sufficient. In those situations, courts would normally appoint, the courts would normally award around 5 to 10%, just as recognition that you are the child and you should have been recognized by your parent. And if you're obviously a minor child, that's different because there is an obligation definitely to support that child. In some cases where kids have been estranged, for example, the parent had no relationship with the child for years, 20, 10 or 10, 20 years, 30 years, um, the court might award nothing to the child, even if they applied, given that lack of relationship. But that's why it's also important when you do a will, if you are planning to disinherit your children for whatever reason, for a lawyer to be aware of that. And normally they would if they take instructions, because we do ask these questions. Do you have kids? Do you have kids from previous relationship? Were you previously married? Because sometimes people mention, yeah, I have 2 kids, but then they forget to mention they were in a relationship 30 years ago and there's also a child. Maybe they live in another country, but they can still claim. So yeah, for the lawyer would take file notes, would make potentially a document that will be kept with your will. In the event should any claim be brought, that there are detailed file notes to explain to the court of why you actually disinherited your children, and that's done to assist you for your wishes to be carried. So, in the hope that the court would understand you and actually not make an award if that's what you wanted.
Awesome. Thank you so much. And final question is, if something happened to both parents, like a car accident, that's what the other person meant before,
Mm-hmm.
about the children. So what happens to the kids then?
Someone would need to make an application to be appointed as testamentary guardian. So you hope that there will be some relatives that would make that application to be formally appointed as testamentary guardian. If there are no relatives, obviously the state would get involved and appoint someone else, foster parents, or yeah. But yeah, if there are other family members, relatives, they would just obviously take the child and then make formal applications to be appointed as that child's testamentary guardian and day-to-day carer.
Well, thank you so much. And the final one is, if my parents have disowned me, and they own everything in the trust, can I contest a will?
No, well, if there is nothing, so when you say will, so you mean estate, because family trust or assets owned in a family trust, they don't form part of the estate, so they completely separate. And if there is nothing in the personal estate in that parent's personal name, then basically you can't contest because there's nothing to make a claim against. Um, and in terms of family trust, unless you were a beneficiary at some point and maybe then you were removed and you have a case there for that, you should not have been removed. So you might have a claim, but that's very different. That's to do with the trust. Mm.
Brilliant. Thank you so much. Carry on.
A lot of good questions. It's very,
I
very
know,
good.
look at the time. We've
Yeah.
been going for almost an hour. This is the
Oh,
first
yeah.
time, I think, that we
Like
just
with
keep
the last,
going.
yeah. We
And it's
probably might have already answered actually, some of these common pitfalls I have there. Probably I might have already answered through this question. So, yeah, I've mentioned the first one, joint ownership. So, yeah, you might leave a house in your will to someone not realizing that it's owned jointly with someone else, not realizing that marriage revokes a will. Very common. It's very common. People think they have a will, they got married, they don't know, they didn't realize that marriage revoked their will. If you are married, but you have separated, you might not realize that if your current will, if you haven't changed your will, where you left everything to your spouse, that spouse tends to inherit under your estate until the marriage is formally dissolved, and that takes 2 years. So if something happens to you during those 2 years, that spouse will inherit under your estate. So if you have a will and you separated and you married, or even if you're not married, you separated, you still need to change it regardless. So basically, you think of it that way: I separated, I need to change my will. And if you have no will, you need to make a will, because if you have no will and you die and there's intestacy and you married, it's sort of the same. That spouse can inherit. So yeah, must make a will after separation. Not understanding the implications of the relationship property law, that's the fact that your spouse might be entitled to 50%. And if their entitlement is crystal clear, like, you had your family home together, you've been together 20 years, all your assets are being accumulated together, they're likely to have that 50% entitlement. So if you leave them 10%, they're probably going to be unhappy. And there's probably no point to do that, because then you're just going to invite all these claims unnecessarily. And remember that when the state fights a claim, the state spends money. So the money, your assets will be used to fight that claim. So again, important to structure things in a way to not disinherit those who are entitled to inherit, not to disinherit, spouses who are entitled to inherit under relationship property law, because you're just inviting a claim that's unnecessary and will just waste your assets. Yeah, not realizing the complexity of cross-border estate planning. So that's one we haven't talked about yet. But for example, if you live in Italy, if you live and die in Italy, but most of your assets are in New Zealand, most likely those assets will be distributed in accordance with Italian law, because your domicile, your place of domicile would be Italy. So even assets allocated here, Italian law would likely apply. And in terms of cross-border, there's all these rules about whether the asset is movable or immovable. And there is conflict of laws between the countries. So it's very important. Like it is generally very complex and expensive. But if you do have assets across jurisdictions, you probably do own, a significant amount of wealth there. So you do need to do that planning. Otherwise, again, unintended consequences. And yeah, I think that's it. So basically around the costs, we already talked about it. Yeah, people can just read, but yeah, the cost for simple will, and I'm just talking from perspective of my own firm where I worked previously in basically Auckland. And I talk about specialist lawyers, as I said, general law firms, for example, firm who does conveyancing, like, buying, selling property, they may attend to it for cheaper, which in most cases is fine if it's quite a simple situation, couple, a family, home, children. But if you do have kids from previous relationship, you want to disinherit someone, you have trust, you have cross-border, yeah, ideally you need to consult a specialist in the area, because it's very easy to miss things when it comes to this complicated issues. Yeah.
Alina, thank you so much. I think this is a very, very important topic for anybody, like I mentioned in my opening brief speech, that if you're alive, if you're over 18, and if you've got anything at all, you should really be thinking about it, and you should be thinking about it as your situation in life changes, marriage, separation, etc. Even buying a new house, for instance, we deal a lot with people buying houses and stuff, and that's part of my advice. I always say to my clients, have you got a will? If you don't have a will, this is the time to speak to your lawyer. And as you mentioned, if you are buying a house, making a will at the same time could actually be a bit cheaper, because some lawyers, I remember when we were buying our first home back many, many years ago, we actually got a will done for us for free, which was great. So yeah, so there are different packages. So talk to your lawyer who is dealing with you. If you don't have one, and if you're not buying a house, come speak with Polina. She's awesome. She's my go-to person. As I mentioned before, she did my will, which I thought I lost, but she's got it, so that's okay.
That's good. I was actually working on updating website, and one of the things I have a meeting, like, because I try to make it easy for people to, book consultation stuff. And a will meeting is called Your Will, Your Way. It resonates with me because I think it's powerful, because when you do your will, it's done your way, You don't have a will, it's going to be done in a way that you didn't predict or maybe you didn't want. So it's going to happen, regardless. But yeah, if you want it your way, you need to have a will. And another advice is, a lot of people think, well, I'm young, I can just do it later. That's great. And hopefully nothing happens to you and you do it later. But the complication as well is a lot. You never know. There's a legal concept of mental, capacity. Do you have the capacity to make the will? So the older you are, the more chances, the higher chances that you might not have mental capacity. And of course, it doesn't apply. It's only small amount of people, but generally a lot of situations where the person doesn't have a will, they now want a will, but they or their family wants them to do a will, but there is no, they don't have legal capacity, and it's too late. So yeah.
Yeah, no, absolutely, Paulina. Thank you for that. We've got a question here coming through. Is there a discount code to get you to do the will for them? I think discount code is my name, Steve. Just
Yeah.
use
You can-
if you
yeah.
can spell it, you get
If you
the
can,
discount.
yeah. Um, just mention Ziboniso, mention this webinar, and we can chat. Yeah.
Yeah, no, that's cool.
Yeah.
Evan, hello. Really good question. Is there an obligation to pay your executor? Can they claim anything for their time if they're not named as a beneficiary? So they're not going to get anything, but they
Yep.
doing all your stuff.
Yeah. No, the executors cannot be paid for their assistance unless the will says so. And it would generally say so when a lawyer is the executor or an accountant or any other professional. There would you would be 99% sure there would be a clause which says that they can be reimbursed for their time. And it's very common, of course, for lawyers, accountants to be executors, especially in complex estates. So yeah, professionals can be reimbursed.
Awesome. Thank you so much. Do you have any more slides? Is it the last one?
Yeah,
Oh,
that's
look,
the
any
last text.
questions? Any questions? If you guys have a topic in mind that you would like me and Paulina to cover, please let us know because we are here for you, because when we know things, we don't know if you know it already or not. We assume you know it. So we don't know what you don't know. Please help us to come up with another webinar idea. One of the ideas I had for Paulina is power of attorney.
I was going to say enduring power of
An
attorney.
enduring
Yeah.
power of attorney. So if you guys, even if you're young and you're traveling, you should have power of attorney set up as well. So if that's an interest for you, please let me know. If you can, for those that are still here, drop in the chat bar if that would be of an interest. And we will run another webinar maybe next month or a few months later. And yeah, so power of attorney, if you know what it is. Paulina, I can still see your screen. Do you want to stop sharing?
Yes, good idea.
Love it. Thank you. Yay. Can see your face.
Done. Yeah.
Awesome. So yeah, if you guys want us to do another webinar, please let us know the topics you would like to hear. Steve is saying, thank you. This topic was really interesting. Thanks so much to both of us. Well, I was just emceeing really. Didn't really talk much. It's mainly
No, you ask good questions. Makes it more interactive and you're good. Right.
Thank you. Very good session. And yes to the next webinar. Awesome. Oh, good idea.
I just saw another question there, Boniso. Maybe you've missed.
Did you? Where? Which one did I miss?
Well, there's quite a few actually you've missed. Or maybe it was, so one was,
I was in the beginning.
How does having a will compare to public trust work? So that was from Jim at the beginning, I think. It's same. Public trust is just a provider, so they just draft wills and they can provide executive services as well. So where they act as executors. So yeah, it's very different. Public trust is basically just, you can think of it as a firm that helps you to draft the will and then can be your executor. And then another one there, what paperwork would you need from your KiwiSaver provider to make sure your family will receive the amount in your KiwiSaver if you leave it in your will, especially if it's over 40,000? So yeah, if it's over 40,000, you would need they would ask you for probate. So they would ask for a copy of the grant that allows you executors to administer your estate. So assuming that you have a will, it will get probated. Then your executors would send it to the KiwiSaver provider, and then they can withdraw the KiwiSaver. Yeah, I think maybe that's it. And
Yeah,
then Jim
sorry,
also
thank you
said,
for
if I
noticing.
have 50% to my partner and 50% to my child, can the will be contested? I don't know if you asked that. I think no. If
I
I have
think
50,
yeah, I think it was going at the same time as you asked, as you were talking about the 1/3 and two
so it
thirds.
kind of made sense. Yeah,
Yeah.
yeah, yeah. Okay, I think that's it.
Awesome. Well, we had an
Okay.
amazing crowd today. Absolutely grateful. Thank you guys so much. If you feel like, we went too fast or you want to watch a replay, please go on YouTube, find my name, and there will be this recording of this webinar tonight. If you haven't followed me on Instagram, can I please ask you to follow me so I can actually go live on Instagram next time as well? I need 1,000 followers. And I'm not afraid to ask to please follow me. That'd be great. Thank you guys so much. And Paulina, mainly thank you massively for your time. I know it's not easy. You've got young kids to jump in at this time of the night to be with us and share your knowledge. Absolutely priceless. So thank you, thank you, thank you.
Thank you for having me. My pleasure.
Have a